Good evening, everyone, and welcome. It's so nice to see you all here. I'm excited to be here. I'm Steve Wolpert. I'm a professor in the politics department, and this is our Constitutional Symposium. We're very glad you're here, whether you're here in person or you're attending remotely. It's a pleasure to see you all. Well, I can't see you if you're attending remotely, can I? But we're glad you're here. We organized this event for two reasons. One, Constitution Day was Saturday, so in honor of that event, we wanted to hold something that would focus on the Constitution. And the second reason is that toxic polarization is threatening our democracy, and we really, really feel it's important to create spaces where people can get together, have honest and respectful discussions about potentially controversial topics. So we're welcoming three recognized scholars, experts on this topic. Before we begin, I want to thank the Jack Miller Center for funding this event, for providing the primary funding, and also the Cummins Institute here at St. Mary's for its contributions to making this event possible. We're very grateful to both of them. We hope you all got copies of the Constitution when you walked in. If not, they're available. Please take as many as you like, share them with your friends. The topic is one that is unsettled. The Constitution, as you probably know, tells us what our rights are, but it doesn't define what those rights mean. That leaves it up to the Supreme Court to say what the words in the Constitution actually mean. So here we have freedom of religious expression in the First Amendment and equal protection of the laws in the 14th Amendment. So what happens when those two things appear to bump into each other? And that's what we're here to explore, particularly with regard to rights for LGBTQ people. This is not a town hall. We're not here to take votes. We're not here to declare one side or the other to be the winner. We're here to improve our understanding of what the issue is and the different facets of it so that we can appreciate the complexity of it and approach it with more trust in other people, more sympathy and tolerance of people whose views may differ from us. We're here as a learning community, and so our purpose here is not to foreclose debate or to provide closed answers, but to help all of us learn more about the topic. So the format is that in a minute I will turn it over to our moderator, who will be having our experts answer questions, and they will discuss the topic for a good portion of the time. I will then, and let me point out that the file cards that you see on your chairs are for you to write questions that you would like to pose to the panelists. And at some point during the discussion, I will have my trusty interns come around and you can pass them to them. They will bring them to me, and so there will be a chance for you to put questions to the panelists. In the meantime, let me tell you about these wonderful speakers that we have here. I'm really thrilled that they're here. I'm so excited. Robin Fretwell Wilson is the director of the Institute of Government and Public Affairs for the University of Illinois System, as well as the Mildred Van Voorhis Jones Chair in Law at the University of Illinois College of Law. She's the author of 18 books, including Religious Freedom, LGBT Rights, and the Prospects for Common Ground, and Same-Sex Marriage and Religious Liberty. She earned her JD degree at the University of Virginia. Kyle Velte is Associate Professor of Law at the University of Kansas School of Law. Her scholarship examines the intersection of sexuality, gender, and the law. She has published in law journals including the Yale Law and Policy Review, Cardozo Law Review, and Connecticut Law Review. Her recent scholarship focuses on the perceived tensions between religious freedom and LGBTQ civil rights. She holds an LLM from Harvard Law School and a JD from American University. Elizabeth Clark is a professor and associate director of the International Center for Law and Religion Studies at the J. Reuben Clark Law School at Brigham Young University. She is the author of numerous books, articles, and chapters on religion and law. She has also participated in drafting commentaries and legal analyses of pending legislation and developments affecting religious freedom, as well as drafting amicus briefs on religious freedom issues before the U.S. Supreme Court. She holds a JD degree from BYU Law School. And our moderator, my colleague here at St. Mary's, is Barbara McGraw, Professor of Social Ethics, Law and Public Life, and the founding director of the Center for Engaged Religious Pluralism here at St. Mary's. Dr. McGraw is also visiting fellow at the Pluralism and Civil Exchange Program of the Mercator Center. Dr. McGraw's research centers on American identity and its moral foundations, the role of religious pluralism in public life, and interfaith engagement. She holds a JD and a PhD in religion and social ethics, both from the University of Southern California. So without further ado, it gives me great pleasure to turn it over to Barbara McGraw to begin our conversation. Thank you.
Thank you, Steve. It is very exciting to have these amazing speakers here today. It's really an honor and a privilege to have them with us. And all three of you have considerable experience on civil rights, public policy, the U.S. Constitution. And I wanted to start with kind of a locating you kind of question. Where do you locate yourselves in the conflict between the religious liberty rights versus equal protection rights for LGBTQ people? And what sources or experiences inform you in your perspective? And I'd like to start all the way at the end of the panel and bring that question up.
Thank you, Barbara. Can everyone hear me okay? Good. I want to extend my thanks to Barbara and Steve for organizing this panel. It's a wonderful opportunity for me. And to my co-panelists, I've enjoyed getting to know you today, and I'm looking forward to a robust conversation today, and this evening, I should say. So in terms of where I locate myself in this conflict, as will become clear, I think, by the end of our time together, is really skewing towards the equal protection end. In other words, mostly denying requests for religious exemptions from anti-discrimination laws, and we'll talk through the reasons for that over the next 90 minutes together. But I want to talk briefly about the sources or experiences that have kind of led me to this location in this legal and cultural debate. And I'm going to start very personally, which is I'm a 51-year-old lesbian woman. And I say 51 not so you can admire my youthful appearance, but because it matters for the history, right? So much has happened in this movement since I've been born. But I came of age and I came out at a time when the Supreme Court had said that it is okay to criminalize intimate same-sex conduct between adult partners. And for 17 years, the law of the land was it is okay to criminalize intimate same-sex conduct between consenting adults. And I came of age at a time where if a woman had been married to a man and came out as a lesbian and she divorced him, she would lose all rights to her child simply because of her sexual orientation. I came of age at a time of the AIDS crisis where the federal government and public health turned its back on a pandemic because of sexual orientation and stereotypes about gay men and who they were and how they were wired and what care they deserved. And I came of age at a time where employment discrimination was rampant against LGBTQ people. So those lived experiences really inform a lot of the perspective that I bring to this conversation. I'll briefly talk about professional experiences and academic training, just to kind of complete the picture of how I locate myself and the experiences I bring. I worked at the National Organization for Women after college, and I did political organizing. It's what led me to go to law school, as my work with NOW. I worked at the National Center for Lesbian Rights in San Francisco during law school. And I've done a lot of pro bono work around LGBTQ rights. So I've thought about this from both a kind of activist and legislative lobbying perspective, as well as legal advocacy perspective. And then finally, my academic training. I was a women's studies major in college. I'm hearing some feedback. Is that me? Is yours off? Should I turn it off and start again, or? I mean, because I just turned it off, yeah. Should I wait, or should I keep going? Okay. I was a women's studies major in college, and that trained me to think critically about gender, about power, about norms, about how patriarchy can kind of obscure inequality and make it look like it's natural, that we don't interrogate it very much. And then studying law, of course, I studied things like critical race theory and queer theory and feminist legal theory. That trained me to kind of see the legal construction of inequality and how law often perpetuates power inequalities and reinforces those and reiterates them, these power imbalances. And then finally, law taught me about the rule of law and its importance, and a lot of that is adherence to precedent and seeking coherence in the law. So that's my positionality, and I'm going to turn it over to, I think, Robin.
Thank you. Can you hear me in the back? Wave? Okay, thanks, man. So first, let me thank Barbara and Steve, but I also want to thank all the students that had dinner with us and the ones who came to class and still came tonight, so thank you. And a big shout out to Brother Charles, too, for all the hospitality. It's a wonderful university, so I really appreciate you. So where am I? I think that we don't have as much conflict as we think. And I think that much of the conflict is more perceived than real. So civil rights aren't like pick this side or pick that side. They're like puzzle pieces. They can be made to fit together. But that takes brave lawmakers and positive law like state statutes or the federal, Congress to do that hard work. Now, it can be done. So just as an example, Utah is a place where I have helped the governor of Utah ban gay conversion therapy. Let me pause and say that again. Utah, banning gay conversion therapy. Utah gave more rights to the full LGBT community than that community had at the time in New York in landmark legislation in 2015. Because they took the notion that people of faith and LGBT persons who look like we think they clash, that they could both be made well in the same law. And I think I position myself almost squarely in the middle, trying to understand everybody who's in this space and what they're looking for. And I think when you come way back up for a moment, you realize that LGBT people can't just shed their sexuality at the door like a pair of jeans or something when they go out, right? They're completely, thoroughly, they want in public and private to be themselves. People of faith are the same. They also want in public and private to be thoroughly themselves. And so the puzzle pieces move requires that you understand when communities are actually looking for the exact same thing. And then how do you find places in the law for both of those people to be fully authentically themselves? Now, sometimes there will be places where you have to pick team A or team B. And by the way, the team language is difficult because there are many, many LGBT people who are people of faith. And many people of faith are gay or trans. So there really aren't like two teams here. But sometimes you do have to pick an interest. And I think in many ways my job, whether it's been helping enact same-sex marriage laws before the court acted, when it was still a question for states, or helping non-discrimination laws be passed, or a state to ban gay conversion therapy. It's like being a mechanic in a way. But smart, clever people can find ways through these perceived conflicts. And I think, in fact, the people who are most likely to do that are members of Generation Z and millennials, because y'all have grown up with more diversity in your lives than almost anybody else. So if we're going to get out of this morass, I think it's you.
Thanks. Both my co-panelists, thank you, Barbara. Thank you, Steve. It's really been a pleasure to be here to get to know my co-panelists. I'm delighted for the opportunity. You know, if you're organizing the panel, I probably fit the slot of religious person. But I think, as Robin said, that's a little bit stereotypical, and nobody can have their identity totally summed up in one word. In fact, I see myself as an advocate for both LGBTQ rights and religious freedom. My background is the intersection of religion and law. Personally, I'm a person of faith. I also have family members who are LGBTQ, who identify. And my background is working with law and religion, and my sense for the need for religious protections comes largely from two things. One, from my international work. I've worked on advocating for minorities everywhere, including the rights of Muslims in China or Baha'is in Iran. People who need help and support and allyship, just as LGBTQ individuals do in our country. I also see the need for religious protections coming from my research, and research that I've drawn on from numerous social scientists looking at the impact for good religion has in our communities. I could go on and on, spend the whole 45 minutes just talking about that, but there's studies showing everything from educational levels for disadvantaged youth, levels of volunteerism, philanthropy, even for non-religious causes, influence on health, the ability to build social capital, giving people a platform where they can speak truth to power, having people build institutions like this here at St. Mary's. I mean, these are all have been documented, associated with religion and religiosity in individuals. I'm also grateful for the opportunities I've had to work professionally with LGBTQ colleagues around the country, and to have events where I can bring them together with people for whom that feels uncomfortable. To be able to have conversations where people are out of their comfort zones. I really like that. And I think, as Robin commented, one thing I've found in trying to bridge gaps and bring people together is that there aren't two camps. Studies show that 60% of LGBTQ individuals are religious believers. In fact, the average LGBTQ individual, according to polls, is female, religious, and under 40. And I've also found, as I've been trying to do what I can to bring people together, is that we need each other. I think of my friend Marian, who is a lesbian and a pastor, and is working in this space. And her comment that she was working really hard to try and help end youth suicide, which is higher among the LGBTQ population, and how she'd been trying in a certain area for years, but couldn't seem to get any traction on support for this until she went to some of the major religious groups in the area. And even though their ideas of sexuality, her ideas of sexuality weren't the same, they could come together on youth suicide, and they did. And she said that's when she really began to see change and movement. I guess that's where my stand, if you're asking where I'm coming from is that we don't have to have the same religious doctrine. We don't have to have the same sexual identities to be able to work together for the benefit of everyone.
Thank you. Thank you very much for those introductory remarks. And so one of the things that we see, right, is a lot of issues coming up in our society, but also through the courts, involving religious people and LGBTQ people. And some of them involve individuals, religious liberty, for example, in Colorado in 2018, where the owner of Masterpiece Cake Shop didn't want to bake a wedding cake for same-sex couple, right? And just this week, there's an issue involving an organizational religious liberty. Yeshiva University is an Orthodox Jewish educational institution, and they did not want to support and sanction an LGBTQ club on campus. And so far, the Supreme Court has been favoring religious rights over LGBTQ rights. But the country is divided. And we have lawyers here, but I'm not so much interested in picking apart those cases as I am interested in, based on your perspective, how would you describe the main dilemma that we're experiencing in our society around these kinds of issues? And number two, what do you think each side needs to understand about the other side? And thirdly, should one side's view prevail in some situations or in others? And how are we going to figure that out? I turned it over to Elizabeth to start, but then we'll open it up to a conversation.
Thanks. Great questions. So what's the dilemma here? Well, maybe if I can start by saying what I think it's not. I think it's not a zero-sum game where every advance in religious freedom comes at the cost of LGBTQ rights or vice versa. I don't think there are two separate camps necessarily. Not all religious individuals oppose LGBTQ rights. Not all LGBTQ rights oppose religious freedom. There are questions where they conflict. I'm not going to deny that. But people are more nuanced when you get to know them as individuals. Even on the question of, say, baking cakes for gay couples in Masterpiece Cake Shop, the case that went to the Supreme Court, the survey said that 31% of LGBTQ individuals either agreed with the store owner or were neutral on the result. Probably not what you're thinking of if you're thinking of camps. And solid majorities of every major religious group in the United States supports protections now for LGBTQ rights in housing, public accommodations, workplace. I recognize that, for many people this is too little too late. But I think that the nuance is there, and we have to think about that when we think about these issues. I also think one thing it's important to know it's not a one-ring circus, right, where you pick one winner. The analysis for different pieces of legislation is going to differ on how they're drafted. Is there a religious exemption? Is there a balancing test? Are these rights set up equally under the law? Was the exemption designed to help put religion in an equal position because they have special hiring needs? Or constitutional rights? Which rights are involved? We think of Masterpiece Cake Shop maybe as a prototypical one, but it's actually a free speech case. It's not a religion case, or at least it wasn't originally. So, and also in the case where there are tension, it's not always a case of one prevailing, right? No right under the Constitution is absolute, and religious freedom is especially so. Even under the most protective standard, which now exists under some statutes and in some states, the government has to meet show this compelling interest for its action, limiting the right. Even in those cases, religious freedom can and has lost to statutory rights, constitutional rights, it's lost to gender rights, it's lost to environmental rights. To say that one favors religious freedom doesn't mean that one is predisposing a certain outcome. Okay, so what is the issue? Now that I've spent all my time talking about what's not the issue, right? And to me, the main dilemma is, as citizens who live in a pluralistic society, how do we recognize everyone's rights? How do we treat everyone with dignity? Right? How do we remind people that we're not free if others are not free also? Right? That we're all entitled to both equal protection and religious freedom. Those are both in the Constitution. Right? This isn't always easy, it's not always obvious, but to me that's the dilemma here. And it's really crucial, as Steve was saying in the introduction, right? It's crucial to our American experiment to find ways to work together for the good of all and not demonize big swaths of society. To me, that's where the dilemma is. That's the real challenge.
Thank you. So, keep forgetting to turn on my mic. I open it up for conversation amongst the three of you. Who would like to begin?
I'll go.
All right, great.
And just spend a minute or two on the prompts that you forwarded to us. In terms of how I would describe the main dilemma, I think there's two things that are at work here that we need to think about collectively. One is what I call exceptionalism, and what do I mean by that? Well, mostly what we're talking about here tonight, not all, but mostly, is when a state passes a public accommodation law, and that's just a law that says, hey, if you hang a shingle in the public square, if you have a business and you open it to the public, the statute will list people that you cannot turn away because of their identity. You can't turn away somebody because they're black or because of their race. You can't turn someone away because they are a woman. There's other protected classes, sometimes with weight or ableism, or also the states get to pick. And so there's about 28 states that have, among those protected classes, sexual orientation and gender identity. So this tension only comes up in 28 states. In all the rest of the states, a shopkeeper can say, I'm not selling you cake because you're gay, whether it's for religious reasons or not. You can just openly discriminate. And so what we're talking about here is when a statute includes sexual orientation in its protections, and then a shopkeeper, because of sincerely held religious beliefs, doesn't want to serve the gay customer. And so one of the things I think we need to grapple with as a dilemma is what's happening when a shopkeeper, a Christian shopkeeper, doesn't want to sell a cake to a gay couple, is they're trying to say, okay, there's a list of like 8 different identities protected. We want to treat sexuality differently. We want to keep, it's exceptional in that way, to pull it out of the statute. We'll follow the statute for all of the other people that are listed, but we don't want to have to follow the statute for sexual orientation and gender identity and those customers here. So that's exceptionalism. The other thing I think we need to grapple with as a central part of this dilemma is history. I think a lot of advocates and courts take an ahistorical approach. They don't remember that we have been through these battles before, and we have a time-tested framework to actually deal with this exact question. And I'll circle back to that in a minute, because I wanted to address the question of what do we need the other side to understand. And I too don't like to put it into two distinct sides, but for lack of a better structure, we'll talk about that. So what would I love the other side to understand about my position in this? I think two things. The harms that are at stake for the LGBTQ community, and those harms are dignitary harms. Being turned away from a shop has deep dignitary harm. Economic harm. If you are turned away, you have to find another shop. And if you live in a place like, I don't know, Telluride, Colorado, or that has like one baker, you have to go 300 miles to find another baker for your wedding cake. There's huge economic harm in that. There's emotional harm in terms of the stigma that can infiltrate and cause depression and anxiety. And there's physical harms, right? Because just recently a court gave a religious exemption to an employer that they don't have to provide what's called, it's PrEP. It's a pill that prevents HIV. And they don't agree with same-sex sexual conduct, and so they wanted to not cover with the insurance the PrEP pill. That has physical harm on LGBT people. So there's a host of harms that can come from these exemptions. But there's harms beyond the LGBTQ community that I want to touch on very briefly. One of those is public health. So during COVID, a whole slew of cases went up to the Supreme Court on what's called the shadow docket. It's not a secret docket, it's a quick docket. It's like when there's emergency has to be done and we can't have the usual system where we have lots of briefing and oral argument. They kind of do it on a fast track. And in those COVID cases, typically laws were passed, like in California, right? You can't go to the shopping center, you can't go to you can't have hairdressers, you can't, all those have to be closed down. And churches would come in and say, wait, if you're going to allow grocery stores to be open, you need to allow churches to be open. And we want an exemption from the otherwise applicable law. And the court granted those in what I would argue is a radical revisioning of the First Amendment. And that threatened public health for everybody, not just the people that were going into those houses of worship when they were crowded and in the thick of the COVID problem. And then the other thing that I think goes beyond the LGBTQ community is the court has really turned on its head a very long-standing doctrine called strict scrutiny. I'm not going to get into the details, but the details don't matter here. But they really flipped it on its head. And they used to ask the question, if we have an anti-discrimination law, does that serve a compelling interest, right? Does the state have a compelling interest in eradicating inequality? And courts used to say yes. That's a compelling interest for the state to make discrimination go away, right? Now they ask, instead of should we make discrimination go away, they say, is there a compelling interest to deny this person a religious exemption? It is upside down. It is a radical revisioning of the strict scrutiny test, and that will impact not just LGBTQ people, but other people that need to go up against the strict scrutiny test. So I wanted to talk about should one side prevail against the other. Is it okay if I do that before I pass it on to you? Okay, I'll do that as quickly as I can and then pass it over to Robin. I mentioned that we have frameworks from history that have helped us noodle through these hard questions before. Because no constitutional right is absolute. Right? All of them have some limits to them, even ones like the First Amendment, speech and religion clauses. And so we have seen this before. So in 1968, there was a brand new civil rights law called the Civil Rights Act. And it said you can't turn people away from your restaurants or hotels because they're black. It was to end segregation. It was a desegregation law. And in 1968, there was a white person who owned a barbecue joint in the South, and he said, I don't want to follow this law. I want to turn away black people from my barbecue joint. And I want to do that because I have a deeply held religious belief that the races shouldn't mix. So he sued the government and said, I want an exemption. I don't want to follow the Civil Rights Act. And the Supreme Court says, no, you can't do that. In fact, the argument that you should not have to follow the law because of your religious beliefs is patently frivolous. That's what they called it. And so the court reasoned when we have a law that applies to everybody, right? We're not singling out people of faith. All shopkeepers have to serve people of color. It's a general law, and so you can't pick and choose the laws you're going to follow when you hang your shingle in the market. And so so the race analogy is one that often people that are litigating from my position will say, listen, Piggy Park is a case that tells us a roadmap. The court said you can't get these exemptions. There's pushback on that. It's a very controversial position because some people say race is just different, right? The history of slavery is just different than the history of LGBT rights, that slavery and Selma are not the same as Stonewall and cakes, okay? Another argument against the race analogy is there's a factual difference. People would argue now that the plaintiff in Piggy Park, that proprietor of the barbecue joint, was actually just really a bigot who was a racist who was hiding behind his religion. And today's exemption seekers are actually, sincerely held. They really truly believe they're not bigots at all. They're coming from a place of sincere belief. And so it would be not a good analogy to make because you are going to brand us, today's exemption seekers, as bigots if you compare us to, the race situation back in 1968. And so a couple of responses to that, and then I know that Robin wants to, I think, talk about this as well. First of all, I'm not saying that race is the same as sexual orientation. I'm not saying that the social, political, and cultural histories are the same. They are not. They never will be. But analogies don't require sameness. Analogies require similarity. And the comparison is of distinct but related things when we draw analogies, and that's what we're doing here. I'm not arguing that we should use this race analogy in all contexts. I'm looking at this particular context where the legislature has said, here's the 6 identities that cannot be turned away. They've treated them all the same. There's no hierarchy of protection. And so to peel off sexual orientation and treat it differently goes against the legislature's intent. And so we need to keep that coherence, and the race analogy fits in right there very well. It's also wrong, this pushback about the bigotry piece is wrong as a historical fact, because in the 60s when the Civil Rights Act was being debated in Congress and across the country, religion was commonly and repeatedly used in opposition to passing the Civil Rights Bill. In the well of the Senate, Well-known senators said, I don't support the Civil Rights Act because my faith tells me the races shouldn't be mingling. It was mainstream, it was not viewed as bigoted, and it was taken as something that was said in good faith. So today, with hindsight, right, we might look back and say, wow, that seems really racist when they were saying those things based on faith. At the moment they were made, it was very much like the arguments today that are being made for religious exemptions. It was seen as deeply held, sincerely held, and legitimate. It was not at all like, these are racist people. So historically, it's the same thing happening now. So the race analogy in Piggy Park works very well to resolve these questions. If we go away from Piggy Park and do something new, that's exceptionalism, and that's troubling because we lose coherence in the law.
Thank you. Who would like to respond and add a few thoughts?
I don't know that I'll be responding, but let me add some thoughts.
There you go.
Okay, so let's go backwards for a second. You know, I think one big thing here is, again, this fallacy that for like one guy to win, the other guy has to lose. Okay, so even the baker is a good example. You know, I think Kyle's exactly right. To walk into a bakery at the single most important time of your life, perhaps. We talked all about marriage today, didn't we? But, you know, you're there to get married, and then some dude tells you that you don't have the right relationship. That's a harm. That is a harm. And we lie to say anything other than that. On the other side of that, for a person who, you know, I don't necessarily love the Jack Phillips fact patterns, okay, because some of the things that he said. But I do think the Washington florist who turned away a longtime customer and said to Kurt and, you know, this couple, I can't make your flowers. I don't think she was judging them. She had made flowers for this couple for a very long time. She was trying to abide a view of marriage that was for her received tradition from Jesus. Now, for that, you know, she was sued by the Attorney General of Washington. She was sued by the couple. She was made personally liable. She had to close down her business. That is a harm. Now, why in the world are we forcing either result? Both results are bad. And you know, if you think about the Civil Rights Act as a barometer here, you're absolutely right. In 1964, we said as a country, you shouldn't be discriminating against people based on their race or their national origin, their ethnicity. In certain things, and these silos were drawn really narrowly. Okay, they were gas stations, they were restaurants, things that we would call common carriers. They were not the entirety of the world. Now, later states expanded these things, but we could get agreement in 1964 that a black couple in Mississippi ought to be able to drive to New York and stop somewhere to sleep and have a place to eat. Notice what we did not do in 1964. We didn't say, okay, if you're seated at this table here with me and, you know, Charles is cooking, that Charles had to make the hamburger. We didn't say that. We said this establishment is open to all people without respect to these characteristics that we think are irrelevant. Where we misstep today is where we are talking about very small businesses, and one person wants to force this specific person to do that. If we did that in 1964, we would have said to the bigot who ran Piggy Park, not only must you allow people in your restaurant, but you will make this hamburger too. We didn't do that. We didn't force that collision in that way. Instead, we regulated the business and the space, and we said it was public for these people. Now, you have this idea of exceptionalism that I think is really difficult. So, anybody here love the Sierra Club? Anybody love, like, the climate, the Earth? Anybody want Earth to stay here? Anybody here want the Earth to stay well? Okay, all of us? Okay, so who should be in charge of the Sierra Club? I don't think we're going to put a climate denier in charge of the Sierra Club. The Sierra Club ought to be able to look at these applications, go, oh, climate denier, not going to actually consider you. Okay? We often talk about exemptions in our Federal Civil Rights Act, the 1972 Title VII, as somehow giving religious exemptions. But it turned out that Title VII is like a big thou shalt not circle. Thou shalt not, like here's this great big circle, discriminate on the basis of religion, discriminate on the basis of gender, discriminate on the basis of race. Okay? Well, so the Sierra Club can all day long, under Title VII, say, climate denier, not hiring them. Now, when you go to the Archdiocese of Philadelphia, or any other one, right, they're going to only interview men to be the Archbishop. They're only going to interview Catholics to be the Archbishop. And they have a specific exemption in Title VII. It's literally like a cutout from Title VII. Think of it as the religious exceptionalism in Title VII. You can call it that. But that carve-out in Title VII was required to put the Catholic Church or any other religious organization in the same position as the Sierra Club. So I think I should be the Archbishop of Philadelphia. It would be a cool gig. You get a great house. You have all these people who listen to you. Far better than some of our jobs. But they will not accept me. And the fact that they are permitted under federal law not to take me because I'm the wrong religion, the wrong gender, the wrong everything, does not make it religious exceptionalism. That exception was there to put religious groups in the same position as non-religious ones. So don't buy the claim that everything in the law is actually some free pass for religious people. It's not true. The law is complex in the way it's created, and exemptions sometimes are there to give religious people the exact same position as everybody else. And I'll stop on that point.
So Elizabeth, would you like to weigh in?
Sure. This is fun. I appreciate the really thoughtful comments from both of you. This was really a fun discussion. I think there's a lot that could be said, and I think the case of public accommodations is certainly the hardest. I think everyone can agree on that. This comes up in different contexts, and different contexts get treated differently. I think if I'm just going to add one thing, it would be to sort of complicate the law governing religion, because it's a little more complex, I think. First of all, the law is set up so that it can distinguish between pretextual reasons and non-pretextual reasons. I mean, think of it this way. It's the classic case of the religious school and the pregnant secretary. That's usually the way it comes up. The religious school has a single secretary. She becomes pregnant out of wedlock, and they fire her. Are they firing her because she's pregnant? Are they firing her because she violated their religious norms about sex outside of marriage? Right? I mean, this has been litigated a number of times. And, each time it depends on the individual case, as it should. But the way the law has set it up is they can distinguish between a pretextual reason. Okay, you say you're firing her just because she's pregnant out of wedlock. But we don't believe you. Because, frankly, you've had all these men on your faculty who've had children out of wedlock and you've never fired them. Like, that works for me. Pretextual. Religion should lose. There's also sort of a complication when it comes to the way the First Amendment's applied, right? Kyle brought up the COVID cases, and they're a little different, and they're sort of complex because it goes back to sorry, I could give you an hour-long lecture and even only barely scrape the surface. First Amendment law in the U.S. has been really complex, but suffice it to say, it's gone back and forth. In the 60s, there was this high water, 70s, high water mark of protection, strict scrutiny. The Amish kids who parents don't want them to go to school get pulled out. They still don't win all the time, but it's still pretty much a high water mark. The Seventh-day Adventist, who gets fired because they won't work on Saturday, still gets unemployment compensation, those kinds of things. Then we get later, and Justice Scalia strikes down that whole line of cases, writes majority opinion, and the Smith case saying, no, religion shouldn't get any special protection. Any generally applicable law should apply to religion as well. But then the cases start looking at this question of, well, what is a generally applicable law, right? Is it generally applicable? And here's the case that will illustrate what I'm trying to say. City of Hialeah, Florida, had a Santeria community. It's a religion that comes out of Cuba, traditional voodoo elements. They sacrifice chickens. City of Hialeah didn't really like them sacrificing chickens, not in my backyard kind of thing, right? And so they passed this city ordinance that covered about every other single way that banned slaughter of animals, but then made about 100 different exceptions for anything you can possibly think of, except religious sacrifice of animals, right? And this came up to the Supreme Court said, you know what, even with our lower standard, this still doesn't meet it because you're clearly targeting this group. And so that's where the COVID cases come in, right? The question was, are we unfairly targeting religion by giving an exception for, places that repair bicycles or sell alcoholic drinks, but don't allow religious groups to function. At any rate, sorry, that's a long, drawn-out way of just saying that this is actually a very complex field, and the issues are hard. And sometimes, judges get them wrong. Sometimes the religious group should lose. But I just think that should be part of the picture.
I bet there's other comments on that question, and I'm happy to hear those, and I want to add a question to the discussion at the same time, and that is, if a compromise is in order around this, and you all are already getting at this to a great degree, is there some approach and legal thought that could inform us about how to do it, that minimizes conflict, like really dig into that way of, or are there other ways of perhaps coming to some kind of solution? And you're already all touching on it, and so I wanted to bring that in, but also if you want to continue the discussion we're having from the previous question, please feel free to.
Okay, so I just have to say one thing about the COVID cases. So the church cases. You had liquor stores that were open and churches that were told no. You had bicycle shops that were open and churches that were told no. And I wrote, 100-page paper about this in St. Thomas. How many of us want to go to law school? I love how you're producing all these kids. How many of us are going to law school? A little higher. I want to see it all up there. Okay, let me give you the one trick to law school. Okay, it's called IRAC. Okay, I want to finish this out for a second. It means issue. Okay, come on, all the ones with the hands up. Issue, rule, analysis, conclusion. What's the issue? Can a church be open and can a church be forced to close and a bicycle store be open? Issue. Is that wrong under the First Amendment? Now, the First Amendment is very complex. I'll agree with that. Rule. Well, you can't encroach on religion. You can't, literally, they use the word discriminate against it, the way the city of Hialeah did with animal sacrifice slaughter when it allowed everybody else to do all kinds of slaughter, but not animal sacrifice slaughter for religious reasons. And they considered that targeting of religion. That's the rule. Analysis. What do you do when Gavin Newsom, for example, goes to these, press releases and starts saying, well, these schools are going to be closed, those churches are going to be closed, these factories are going to be open. And when you actually go read the court cases, turns out his own experts went into court and said things that undercut the governor's specific claims. Like they would say, oh, well, factories, they're safe. Why is the factory safe? Well, because people can walk in one at a time at the factory. And then they said, this is a wild claim, that employees listen to employers. Not really. They don't. In fact, I think many religiously observant people are going to, listen to their pastor before they listen to an employer. And just like a factory can stagger people walking in, right? A church can schedule appointments, and many of them did. And so the real trick to the COVID church cases, whether it was Nevada, California, or New York, that was enough for me to write about, that was 100 pages, right? And they were all the ones that kicked up to the Supreme Court, is that the governors never bothered to explain themselves. It was a problem of arrogance. They didn't connect the dots, and their own experts went into court and undercut their claims in great detail. And by the way, all of the churches and synagogues that sued over that received attorney's fees for those cases. Every single one costs the state money. In any event, that's not a place to look for compromise because the governors didn't even try. You want me to go on the compromise part? Okay, happy to do that. So look, is a compromise in order? Yes. We have to quit being at each other's throats. And we are trapped in these positions by the law. The law makes us believe that we have to pick one side or the other. And oftentimes what needs to change is not the views of the people, it's the law. The law needs to be changed in a way that takes people out of it. So how many people remember Kim Davis? Remember the lady in Kentucky who was so horrible to the gay couple that simply wanted to make, this case, right, both of you? Right. And like what? Made them stand there for 5 days because she didn't want her signature on the form? Okay, well, she's not a great poster child for religious liberty. Let's just say that, right? The lady's not sympathetic. That said, many people, when same-sex marriage was enacted, actually did have a crisis of conscience. They weren't trying to block gay people from marrying. They just wanted to step to the side of it. Now, they're government employees. Really hard to think that we should let a government employee step off from this. But there are states like Utah that actually, by settling down these issues, by trying to solve them, by trying to thread the needle, were able to enact protections that they never could have done if in the crosshairs were religious people. They just never would have gotten it over the line. And what did they do? Did they pick Kim Davis over the gay couple? No. Did they pick the gay couple over Kim Davis? No. They rewrote the entire structure of the problem. And they did it by saying, look, it's a civil marriage. Not everybody wants to religiously marry, right? Many of us aren't religious. But we want to be able to go get the certificate from the court. What do? From the courthouse, like from the clerk's office in the courthouse. So they said, just outsource the problem. If you don't have willing clerks, then allow any authorized celebrant in the community who is willing to marry people on the same basis. And that's a lot of people, by the way. That's like judges and mayors and religious figures and all kinds of people that are authorized. And they just made the problem go away by taking out the clash. Clashes come from finitude. They come from having a scarcity, and then we got to pick a team. And they just said, well, to hell with the scarcity. We will allow anybody who is able to authorize people under state law to do that, as long as they do it on an equal opportunity basis. Now, how many of you like Jaguars? Anybody here like fast car Jaguar? She's only one. Really, one person? You kidding me? Okay, a lot of us like Jaguars? Yeah. So I used to say, but I'm afraid you'll Google this, so I'm not going to say it this time. I used to say, I'm a very old Jaguar, 25 years old. I love this car. That I would give my Jaguar to anybody who could name the 2 counties in Utah that use this mechanism. And you can't. You know why? Because the only thing we care about in America to report on is conflict. Kim Davis. You don't have any idea that 2 counties in Utah solved this clash without anybody being harmed. Now, if you Google it, You might find it, and then I'd have to give you my Jaguar. So I'll stop on that point.
Kyle, I'd love it if you'd come in on this.
Yeah, I'll chime in. I hope there's a compromise space, but I think I'm a little more skeptical than maybe Rob and Elizabeth are. And I want to kind of zoom out from this particular tension and talk a little bit about how things are all connected. And what do I mean by that? I mean, to get legislative compromises in state houses, you need free and fair elections. Okay, and so the U.S. Supreme Court has demolished voting rights, right? The Voting Rights Act is gutted, so now people of color in the South in particular don't have the access to vote that they did. We have new voter ID laws that are coming in that transgender people, if they can't get a document that aligns with their gender presentation, they'll be turned away at the polls, okay? So they're not voting. We have new laws that say you can't use drop boxes for your ballots, and that cuts out mostly lower socioeconomic people who can't take time off of work, so they have to go drop their ballot, and that also disproportionately impacts black and brown people. We have gerrymandering that's happening in state legislatures where when they do redistricting every 10 years, there's a ton of dark money going into this. That means that donors are not identified. Millions and millions of dollars to go into gerrymandering districts so that red districts with very conservative Republicans, who, by the way, most Americans don't go that far to the right, not at all anymore. But those are the people that are getting into the state houses, and the Supreme Court is leaving those redistricting maps alone. And in fact, has a case on the docket for this fall where a totally novel theory is being articulated that when a state legislature makes a new map, the state Supreme Court is not allowed to rule on it. Now think about that. State Supreme Courts, their job is to say whether state law is good or not, right? That's a state system. This case argues that only the federal Supreme Court can take a state redistricting map and say if it's good or not. That is outrageously radical if it comes to pass, and it likely will. So to have the kind of compromise that Robin laudably and I admire in Utah, which was it's called the Utah Compromise. Everybody knows what that means, and that's Robin's work. I am skeptical that could happen given what the court has done to voting rights, which has disproportionate impact on the stakeholders for the religious exemption cases.
Okay. Thank you. Actually, I appreciate you bringing that up. I am deeply concerned about gerrymandering, about voting rights, about where the country is going. Yeah, that's a whole other conversation. We could be happy to. Steve, are you ready to sort of bring us back a few more times? All right. Good. But thinking about sort of, okay, compromise. Is this possible? What are ways to minimize conflict? I came up with three things. First, to remember that rights are bundled. This is an insight by Amartya Sen, Nobel Prize-winning economist. And you find this internationally, right? Where civil rights are protected, they tend to be protected as a group, including religious freedom and LGBTQ rights, right? This is levels, and studies have shown levels of religious freedom in a country correlate to protections for LGBTQ rights. Often just because it's the same impulse to marginalize, whether it's marginalizing LGBTQ individuals, marginalizing religious minorities, and institutions that will fight against LGBTQ discrimination are also like the EEOC, sometimes fighting against religious discrimination and trying to help sensitize people at all. Sometimes it's a big challenge. And I work a lot on international human rights issues, serve on an advisory committee for the Organization for Security and Cooperation in Europe, a major international organization. And these kinds of issues come up all the time. Gender and religious freedom and other human rights, religious freedom and LGBTQ rights, which are pretty well established in Europe. And there's just sort of this understanding that, well, of course they are, but they're all part of the human rights canon, so we have to try and interpret them in a way that's maximally protective of everyone, right? Not always easy, but it's never always easy to do constitutional law or human rights law. So that's the first principle, it's just right, the rights are bundled, they come together. Secondly, I'd say political branch versus judicial branch. Despite the fact the Supreme Court currently is a big fan of religious freedom, I don't think it's as helpful to go to court. You get a winner, you get a loser. It sets up for more contention, more anger, more polarization. Right? Sometimes it's necessary, but if we can avoid it, so much the better. And even there's been some discussion about how can we better protect both religious freedom and other rights. This question of the standard for the First Amendment of generally applicable law is up for grabs again. And the discussion is sort of like, well, should we go back to the old high standard? No, maybe we should find something in between. That's sort of where the discussion is right now. And as well as Kyle's point, I completely agree. We have so much polarization and dysfunction in our system, but I think it's all we've got. And we have to keep trying to make it work. Certainly, I'm from Utah. No one thought the Utah Compromise was going to work before it came. And so I think it's ultimately the only way we have for compromise. Courts are not a vehicle for compromise. Negotiating, deal-making. This is political branch issues. Because if we're trying to preserve the deepest commitments of the maximum number of Americans, we have to find a way to work together. And the third point is that we can build on human connection and start small if we have to start small. Robin's told you a little bit about the Utah Compromise that really is landmark in so many ways. But what most people don't know is that some of those relationships that led to that started about 7 years before with behind closed doors meeting between high-level religious, political, civil society folks and just building trust and getting to know each other. Then, after a few years of that, they started cooperating on a city council housing rights for LGBTQs legislation. And that worked. And so it spiraled up. But it started from just human contact of people getting together. I know a similar story that I think we'll probably need to move on. So I won't tell you the similar story. Ask me later, and I'll tell you just this amazing story of people working together on the ground floor. But I think compromises.
So I don't want to interrupt the conversation,
Please.
but if you wrote a question on your file card, please pass it towards the center, and our interns will collect them and bring them to me so we can get some questions from the audience.
And I was just to say, let's move to our questions.
So while we're doing that, I'll just say compromise is not a 4-letter word.
And while we're doing that, I would love all the aspiring law students to consider the University of Kansas School of Law. We are fantastic. Come talk to me about admissions when we're done.
Yeah. And while we're in a pause, we've got 4 lawyers here, and I think we're all pretty clear that taking things to court is not the best way to resolve problems, unless you absolutely have to. Then you do, but working through the system is often the better way of making something happen.
And I think there's this kind of urban myth or legend that, the sexy way to get change, the coolest way to get change is big impact litigation, right? Mm-hmm. Let's go do Brown versus Board, but for gay people. And, there was a book, I forget who wrote it, The Hollow Hope. I don't know if I know you read it, but it's about how courts are not the savior of civil rights. There's other ways to get at it, and people go to that as this is how you do it, but from the ground up is better.
So, what do you make of parents who claim religious freedom in opposition to LGBTQ education in the schools?
Who would like to start off on that one?
I mean, I think there's constitutional problems with that law. I'm thinking about the Florida law, the Don't Say Gay law, and other states are thinking about you can't say the word homosexual in class or take books out of libraries. That's where we are is really concerning to me on a collaborative level as a society who's trying to work through difficult issues, right? Because just pulling the books off the shelves or not talking about it in class doesn't make gay people go away. And in fact, it harms those children deeply to not see themselves and be recognized and respected. And I could give you stats all day, which I won't, about the suicide rate and depression rate and the bullying rate and all of that. It's really hellacious to be in school if you're a queer child right now in some states because the protections are just not there. So there has been a lawsuit filed. I think there's some freedom of speech issues around that. It could be, I think you could make an argument that it is sex-based discrimination under Title IX for some of these kids to not have, for example, be able to talk about these things in sex education. So there are ways to get at it, again, through litigation, but I like to back up, and I think somebody mentioned this before, which is let's find common ground with these parents. And the first question I would have for these parents are, would you rather your kid to be dead or alive? Okay? Do you want them to be alive and gay or dead and gay? Because they're going to be gay. And so if we can agree that we want your kid to be alive, then let's talk about how we're going to get there together. And so those are the conversations we need to be having rather than going to court. Or maybe it's both and, right? Often it's both and. Because these things take on a life of their own, and then one state does it, another state does it, another state does it. That's where litigation can help, right? Change the onslaught, right? If court says you can't do this, then we're going to have not that being repeated everywhere. But those are my initial thoughts.
Maybe I'll just add a little bit, but I appreciate what you said. I totally agree with you. I think that, there's a speech issue. It'll be interesting to see the Title IX claim. I think the parental rights one goes way back to World War I era, where there's a question about parents and putting their children in private schools, and that's the case that established the idea that parents do have rights over their children's education. But I think there's a difference between parents opting out and sort of changing the whole system in a way that is harmful to others. I think it's, and I like what Kyle ended up with as well, that actually the story I didn't tell had to do with trans kids in school and this question of, a school board meeting where people were literally throwing things and screaming at each other in Loudoun County over the issue. And, somebody said, look, there's got to be a better way. And so she got a small group of people together who said, look, we think that there can be ways to work together if we work together, and tried to meet separately with some of the parents who had concerns on either side. And, at first they got a lot of parents interested in religious freedom issues, and then they realized some of them, religion is just a pretext. So they sort of focused on the ones who actually had real religious concerns, and then they talked to Equality Loudoun that was there representing the LGBTQ students, and at first they were concerned they're going to be sandbagged or something, understandably, right? This is a really fraught issue, and people's emotions run high, but they finally agreed to meet, and they met and spent, the first 3 hours just doing what they called silly trust-building exercises, right, to get to know each other and laugh and see the other person as human. And then they worked on they had like a shared Google Doc or something, and wrote down sort of, here's some things that we think we can all agree on. Can you agree on this? Let's reword it so that we can agree on it. They ended up coming up with 10 things they agreed on. They decided to take 8 of them to the school board. They took them to the school board, got accepted unanimously. These were all unanimously from a group of very diverse people who'd been at this screaming, shouting match. So I think there's hope, but yeah, it requires a lot more than just sort of pretending the issue should go away.
So Steve, why don't we take a couple of questions and throw it out there? No, that was great.
That was great. It actually answered, in a way, responded to one of the questions, how do you create common understanding to start from and work towards more from? So thank you for that. And related to that was, how realistic is compromise or fitting the puzzle pieces together at the federal level, which again also, it's kind of a scaffolding question. But then here is a very con law kind of question. Is the Obergefell ruling really contingent on the right of privacy outlined in Roe, or is it more about the liberty protections argued in Loving v. Virginia? You'll probably need to do a little explaining about the...
Yeah, so at the federal level, we're so polarized. Has anybody seen Congress do much? Anybody seen Congress do a lot? We've spent a lot of money. We've had some log rolling, but we haven't seen a lot of substantive work. Okay, so it's maybe one of the places where I'm not the Pollyanna in the room. But that said, there is the Equality Act. It's been there for a long time. We're evenly divided. You talk about maps and politics and look at Georgia. Okay. I don't know that that's going to get better anytime soon. And you're going to have something like a consensus, or you're going to need LBJ, to go like strong arm a bunch of, holdouts to get it done. And I don't see that all coming together. There is a credible piece of legislation that is in the mold of the Utah Compromise that is trying to take seriously the claims of religious people and the full LGBT community. And I think it's not perfect. I think it is an honest attempt to combine things. But it relies in some ways on an idea of a balkanized society. So when we talked about the baker, the baker's not necessarily saying gay people shouldn't get married, not saying that they couldn't be served in that person's shop, just saying I want to step to the side of it. And I think some of the devices used in this Fairness for All Act are like that. They are like saying these religious groups or spaces can be islands unto themselves. And I'm not sure that we're willing to accept that. Now, there's a sort of idea going on this panel for a second, though, that the only place that any of this kind of idea of puzzle pieces ever worked is in Utah. That just ain't so. So if you look at what happened before Obergefell, since that's where we're going next, you had 10 states in the District of Columbia, by law, create same-sex marriage. Create it. And they did that precisely by allowing some religious groups to step off. And those step-offs lowered the temperature on things. And you can go look empirically that they pulled things like the Republican Senate in New York. Did anybody know there was like a Republican in New York? Turned out that they had a block on this. And the Republicans were able to get over themselves and allow same-sex marriage to be enacted in a way that cannot be taken back, the way we fear about Obergefell now, unless the whole legislature did it, by allowing people to step off. And does anybody notice any of these step-offs right now? Like, you feel like it's so horrible? Probably not. They were, in some sense, easy things to give away for a really big deal. I think we have to think about that when we think about the ways that we proceed.
I'll jump in quickly on the substantive question of Obergefell and whether it's hanging in the balance. It did have two grounds that it was based on. One was due process and one was equal protection. And so if you're kind of making the connection to the Dobbs case and whether, marriage equality hangs in the balance because of Dobbs, Dobbs was a due process claim. And so there's still an equal protection ground that could protect marriage equality. Justice Kennedy is often criticized he's often seen as the hero of LGBT people because he wrote 5 opinions that were all pro-gay when he was on the court. But he's also sometimes, at least by scholars and lawyers, sometimes criticized for his sloppy or kind of not precise reasoning and kind of blending stuff, not being super clear about what he's doing. So there is an equal protection piece to Obergefell. It's not crystal clear, right? He didn't say it's sex discrimination and this is why, but there is a ground there so that even if Dobbs were to take away the due process reasoning of Obergefell, there's still the equal protection leg to stand on.
Can I make a short intervention on that? So, look,
And then we'll go to another question.
yeah. So, what the hell was Clarence Thomas thinking in this concurrence? To sit there and open this can of worms, like, you with me? I mean, what were you thinking? And I just want to say how angry it should make us, all of us. The idea that, first of all, Obergefell stood 1 foot here on equal protection and 1 on due process. Okay, and he's like messing with this side of the ledger. But you think about what has happened in this country. Hundreds of thousands of families have married with with all the protections that come with that. You mean to yank that back? Hundreds of thousands, millions of children know that their parents have these protections. You mean to yank that back? And then you look at Roe, okay? So we have been divided about Roe v. Wade since Roe. We've become more divided about Roe v. Wade and abortion since Roe. We have anything that looks like that when it comes to contraceptives. Who loves contraceptives? Everybody. Woo, we love contraceptives, right? Everybody loves gay families. And these families have the protections of marriage. So the idea that we were going to go pull this back, I have no idea what he was thinking. And in some sense, it's so destructive. So destructive.
Steve.
Wow. Okay. So this is another one of these sort of.
There's no strong opinions up here.
Yeah. How are we doing? Yeah? Isn't this wonderful? I'm just having a great time. Okay. So this is a hard one. My former church's head pastor baptized a gay woman because in her country it was illegal to be gay. Our pastor was effectively fired due to community backlash. What should we do about this?
Sure. I'm happy to pontificate about this. Right. But, I think this is not a legal question. Clearly, right? This is a moral question, a community question, a personal responsibility question. If you disapprove of the pastor being fired, you could go to the rest of the community and try and get the decision changed. You could leave the community. That's the great thing about religious freedom is you can. You can go ask that pastor to start a new community and support them and see if you can get people to leave from your past community or from others to join. To me, that's what the genius of religious freedom is. We don't have to agree on religion. We don't have to agree about sexuality. We don't have to agree about so many things. But, I have to explain that. I work a lot in parts of the world where there aren't basic rights and freedoms on any level. Just came back from Central Asia, from several countries where religion is highly restricted, as well as, LGBT rights aren't even on the map. And to be able to make those choices, it's a great thing to be an American sometimes. So, I don't know if anyone.
Does anybody know Dietrich Bonhoeffer? Surely, yes. Somebody, it just the first thing that flew into my mind, Steve. Bonhoeffer was a Lutheran minister. He was put in concentration camp at the end of World War II. He tried to assassinate Hitler. Well, okay, that seems a good cause. Surely, yes, right? But another you don't join a concentration camp, okay? Another person at the concentration camp went up to Bonhoeffer and challenged him and said, how can you, as a Lutheran minister, actually try to assassinate somebody, even if Hitler? And he said, if there was a drunk driver who was coming down the road and hitting people or just reeling around, he said that my first obligation as a minister is not to bury people or comfort the mourning. It is to wrest the wheel of the car from the driver. And we do these these things, this pastor. I think God bless the pastor is what came into my head. But we do these things out of conviction. And Bonhoeffer said one time when he was challenged about the uncertainty, how can you know that the driver was drunk? And he said, well, sort of doesn't matter. Because we have to act with what we know, and we actually will, I think the line was, that we have to take this risk even at the price of tainting our own souls.
Wow, thank you.
Wow. Thank you, everybody. I'm having a moment. I'm reminded of a quote from Arthur Koestler, it's coming to me because so often something happens, a stimulus, we get triggered, we have a response that's sort of habitual. We hear a certain phrase and we automatically go to, oh, that person's crazy or weird or something like that. And he said, between the stimulus and the response is a gap. And in that gap is our power and our freedom. So what I'm appreciating here particularly is that, for me at least, I'm hearing people in that gap where we can choose to respond in a more humane, more heartfelt, more authentic place, instead of out of our habitual, customary labeling and othering and so forth. So thank everybody. So here's another question. How important is language in the law? For example, the difference between LGBTQ plus and queer. Does it matter?
Who would like to take that?
I mean, I tell my students, particularly my 1L students, all the time that precision in language is what law is about. And so if they say something that's a little bit right but a little bit sloppy in how they speak to me about torts or evidence, can you please reframe that using precise language? And so when it comes to protections in these laws that we were talking about, these public accommodation laws, generally we use the terms sexual orientation and gender identity. And those two things cover the waterfront of what would be more kind of common parlance on the street, right? I mean, sexual orientation and gender identity would sweep in queer, would sweep in asexual, would sweep in non-binary, it would sweep in all of those things that are a lot more nuanced and a lot more precise about a particular person's identity, but they are good categories because I think at least they do the work they need to do in the statutes and include all of those identities in the law. So I don't know that we need other precise language in the statutes, but I would love if y'all chime in if you think we do. But I think they do the work they need to do in the statutes. But it doesn't mean that we don't need to do education outside of the law to educate our communities and particularly in schools and young children about the terminology, right? That maybe lesbian doesn't fit me if I'm this age and this gender identity, or what does it mean to be non-binary? What does it mean to use they, them pronouns? Because another area we didn't get into and don't have time to is some school districts have passed pronoun policies that say you have to use pronouns consistent with gender identity. And several teachers have sought religious exemptions and said, well, my faith teaches me there's binary sex, male or female, and that's how it stays. So I don't want to use they, them. And so that's another kind of harm to students in those settings. So that I think there's more collective education we can do outside of the precise words of the law.
So I'm going to do a typical law professor move and reject the question and answer a different question. Yeah, so no, I think I'm less concerned about the law. I think your points are all well taken about SOGI laws. I think they're exactly right. I do think, though, that we have to ask ourselves, the person we're talking to, could we try to understand the term that they would want used? We're doing a big access to justice report from my institute right now. And we have used census words for categories, Black, African American. So we have a language for some things sometimes. But I think the most important thing is, how do we get to a place where we can ask each other, even something as impersonal as that, is the right word here queer is the right word here, LGBTQ. And we can't even have that discussion in America. Many of us are terrified to even ask that question. So how do we get to that place?
I think that's the reason we wanted to have a discussion like this, because people often can't have these kinds of conversations without feeling that they're going to be completely trashed for anything that they say one way or the other across the spectrum of ideas around us. And the discussion like this is so important because of the kinds of nuances. We didn't have a question about the media, but the media plays a major role, especially when we have these legal cases, and then they really pit each other, people against each other, making things like the Utah Compromise practically impossible, because then people want to identify with this camp or that camp, and things become like extremely rigid. I see you making notes. Are you wanting to? Oh, I know, because
I actually think this is really good. I want to plagiarize this part.
Well, maybe we could turn to another question.
Yeah,
then.
I think we have time for one more.
We do.
And I want to introduce a word here called litigiousness, which is the propensity to resolve problems by taking them to court. And I think we all know that our country is number one when it comes to being litigious. We have the highest ratio of lawyers to the population. The gross lawyer product is gigantic. There are other countries that don't have enough lawyers. Maybe we should export some. But sometimes the law is seen as a way of getting our political aims through other means, that it's not really a legal problem, but we think the courts are more likely to be friendly to our claims. So let's just try to find a legal argument and see if the courts will help us out. So this, I think, goes to the pretextual issue, and obviously it's, on case-by-case basis. But are there any indicators that would help you determine when a religious claim might not be genuinely religious?
And I just want to add one thing, and that is that in this country, we tend to take this kind of two sides to be adjudicated as a way of having our discourse. And there isn't even a judge, right? And so people will be arguing these two camps, and it has infected our entire culture. And it doesn't belong in that. It doesn't belong in the culture in that way. These things that you all are talking about working from the ground up and getting to know people, is really more the direction. But take Steve's question, for sure.
Yeah, absolutely. And, actually, one quick comment to this question of two sides. I mean, the media feeds into. I remember reading a book by Deborah Tannen, who does work on conversation styles, and she had a famous one on men and women, on mothers and daughters, employers and employees. But she had one section at the end of a book where she was talking about in political life, and how in the United States the image is always that of a debate. Right? We're going to have a debate. We're going to really explore this issue. We're going to have both sides. Right? We don't even think about the assumption that means. What does it mean when we have both sides? It means there's only two sides. And she talked about how in Asian cultures, where there's much more tradition of saving face and not shaming other people, that they almost invariably will have three people. So my hat's off to you all for organizing it this way, right? Where if there's sort of a confrontation going, somebody else can help the others to save face. So, that's their own tradition. But this sense that conversations sometimes work better as discussions rather than debates, I think, is a big one.
I would just quickly weigh in that, I guess, two quick things. In terms of courts are not competent to weigh the sincerity of religious beliefs. That is not their role. they're not equipped to do it, and it's against the First Amendment. So if someone comes in and says, my deeply held religious belief is X or Y, we don't want courts looking behind that and saying, well, is it really true? And we don't want courts to make a normative list of like, oh, that's a racist religious belief, but that's a good one. Like, that is not the role of courts, and I don't think any person of faith would want the judge looking behind the curtain of their faith and putting it in the good category or not. So that's just not the competency of courts, and it's against the Establishment Clause. But, that kind of addresses your question. I guess the other thing I'd say about frivolous litigation, I think, is kind of where that was going, frivolous litigation. Litigation is a huge time suck. It takes a really long time for a case, especially if you're going to litigate to the U.S. Supreme Court. I mean, we're talking years. It's really expensive. So most lawyers just don't say, let's go and take this to the Supreme Court. I mean, first of all, they take 6% of the cases on cert. I mean, very, very few cases they take. They don't have to take cases. They get to choose. And so are there frivolous lawsuits out there that maybe are pretextual? Probably, but the vast majority of them are by really smart lawyers who thought a lot about the strategy and about the depth and strengths of their claims, because it is a lot of resources to put into litigation like this. So I give the benefit of the doubt to people when they file suit that they are good faith claims, that they think they've got a live, important question that they need the court to answer, because it is not for the faint of heart to go into litigation that you think might end up at the U.S. Supreme Court.
So we're to the end of our time, but I'd like to give each of you a minute to say a final word. Who'd like to begin? All right, I'm picking somebody like I do in my class. Robin, you're on.
I knew I was going to lose. Okay, so I get to go first. How many people here are under 25? Is that a legal question? I'm sorry if I asked it. Okay, this is hopeful. This is good. Because I actually think that in your relationships, you have actually included each other and respected each other more than the oldest people in these rooms, generally, on balance. I think it's because you've grown up with such an inclusive friend set and really, frankly, the most pluralistic America we've had. So people have to navigate these things. And whatever it is that you're doing in your relationships, we need to sort of distill those insights, bottle them, and ship them around the rest of America if we're going to get out of this. So plaudits to you for being here at 9 o'clock. It proves my entire point. Right, that this is the way forward.
I think I would piggyback on what Robin said and encourage you to not just have these important heart-to-heart kitchen table conversations with each other, run for office, right? Run for office with this kind of open mind. Collaborate, even if it's local school board. I mean, it doesn't have to be I'm going to go run for Congress. In fact, I think school boards are one of the most powerful places to be. You can talk about these things, about curriculum, about sex ed, about open and affirming classrooms. So you can make massive changes by running for the school board. So I'm hopeful, like Robin, that, we're going to make progress because of people like you. So keep talking and then walk the walk in what you do in your life. And I just want to express my gratitude for tonight, because hopefully we've modeled how we can have hard conversations, how we can be vulnerable and support each other, and work collaboratively. Even if we disagree on some big pieces, we can still sit and have a conversation that I think moves the ball forward for everyone.
Thank you. Yeah, no, I am so grateful for the chance to be here and for all of you in conversation. I think, I think in contradistinction with this sort of hope that I think we all feel from young people in our society, I think there's also the reality that Steve started us out on, that there is a lot of polarization. I read just a day or two ago about a survey coming out of UC Davis that polled 9,000 Americans, and more than half thought there would be a civil war in the next few years in the United States. And it's sort of staggering to me, and I think we've got to do better. And it's hard issues like this that divide people because we don't want to take on. It's uncomfortable. It's the difficult conversation. it's the people we'd rather not have to deal with in some cases, right? But I think my experience has been when I've reached out of my comfort zone and tried to make friends and get to know people who aren't the same as me, that it's been an enormous blessing. Thanks.
Thank you all, and thank you all for coming. Your final words, Steve?
Well, for me, this is a sacred space. That's what I would say. Thank you, everybody, for such a wonderful evening, and take care. Go with peace, be safe, be healthy, and thank you for your time.